A new USCIS policy can have devastating consequences on students who overstay or violate their status. Stay tuned, we'll talk more about this now. Hello everybody, my name is Jacob Sapochnick and I'm an immigration attorney based in San Diego, California. In this video, we're going to talk about the new USCIS policy coming up August 9, 2018 that will change the way students, F students, J students, M students are considered to be accruing unlawful presence in the US if they violate their status by not going to school or working. So let's start by way of introduction. So typically in 1996 there was a legislation passed that determined who and how you can accrue unlawful presence. So in that legislation in 1996 they determined that if you overstay your status by more than 180 days, you can be subject to a 3-year bar, and if you overstay by more than a year, you can be subject to a 10-year bar. We call this the 3 to 10-year bar. So they determine a sort of a period of overstay, which can subject you to those bars. But students, those who came on an F visa or J visa or an M visa, they never had an expiration date. So typically if you enter the US with an I-94, you get a 6-month stay if you're a tourist, or if you have any other visa, depending on the length of your stay, your I-94 determines that stay. But student visa, students, they had a duration of stay, DS, which means that there is no determination as to when their status expire. So students, there's distinction between violation of status and accrual of unlawful presence. So those students, while they violated their status by not going to school, they never accrued unlawful presence because they had that DS notation. The only way they could accrue that if they were apprehended by an immigration official, by a judge, who determined that at that moment they accrued unlawful presence. Now, all that is going to change on August 9th in the new memo issued by USCIS, and that new memo basically will state that students, even if they have this DS notation on their passport, the moment they not go to school anymore or violate their status, they're going to start accruing unlawful presence from that day, and they don't have to wait for determination. So from August 9th onwards, such students are going to start accruing unlawful presence. That is not going to be retroactive. That's only one good thing about this legislation. But everything else is really, really complex, because right now, if a student, and this is a real case that I'm actually handling right now. So a student has been here for, let's say, 18 years and petitioned by her parent, and now before August 9th, if that person goes to an interview, at that time of the interview, the officer will determine the unlawful presence, and the accrual of unlawful presence is going to start from that date, not 18 years ago. Now, if a person is working illegally, that can be an actual bar for adjustment, and that's a whole different thing. But the essence of accrual of unlawful presence will happen at the time of that interview, when that person will meet the immigration officer. Now, after August 9th, all this will change, because once those students violate their status by not going to school, or the I-94 will expire, the I-20 will expire, then they will be considered accruing unlawful presence from August 9th onwards. Now, what can students do? If they are here now before August 9th, they should try to speak to an immigration attorney to see what they can do facing that change and the upcoming date, because after that they will be accruing unlawful presence, and it's important to make planning, because we have the 180 days, then you have the 1 year, and it's important to plan that. So going forward, it's really going to impact a lot of students that are currently in school or are not in school, and they violated their status, but they have not been accruing unlawful presence, which means that if they're going to be trying to change their status through an adjustment, through a parent or through a spouse, those things are really important. So right now, keep in mind that this is a policy change that is coming in August 9th. It will be impacting all students that are here on DS status, that currently are in violation of status. It's not going to be retroactive as far as we understand from the memo. It's going to be effective from August 9th. So anybody who is in violation of status will start accruing unlawful presence from August 9th onwards. It's really, really going to be devastating to a lot of students. And I know that the education community is out in rage on this, but it's important to understand that there's a difference between violation of status by not going to school or by doing something else and by accruing unlawful presence. Until this memo is in effect, those students are not accruing unlawful presence, but they will from the date of this new policy. So it's important to understand and plan how you're going to be, if you're planning to change your status. There may not be a possibility to do that anymore. Looking ahead, when are you going to be accruing unlawful presence? How much? Those considerations must be dealt with your immigration attorneys, and I can see that it's going to be a big problem. So once again, students that are currently in violation of status are going to start accruing unlawful presence after August 9th based on this new memo. If you have any questions, please post them in the comments below or email me at jacob@h1b.biz. This is a really complex area, and we hope to provide more updates very soon. Thanks for watching, and we'll provide more videos and updates in the next few weeks. Bye.